You may have seen in the press that the CPS have admitted that during the initial Lucy Letby trial, they put in some erroneous evidence, all to do with the sort of key cards for the doors. And that only came to light in the retrial on the counts that there was a hung jury on. Now, this is quite a controversial case and lots of people have very strong opinions both ways on this. So what's this about and will it make any difference? To cut to the chase, my prediction is no, it won't. It won't make a slightest bit of difference. But perhaps I can explain why, and I'll also explain the sort of background to this, and you can form your own opinions, because I certainly don't claim infallibility. But what happened? Okay, at the retrial, the CPS said, we had mislabelled the key swipe data. That's the stuff that showed, as people go around the hospital, they sweep in and out. And they accepted that it was actually wrong at the first trial. Now, the defence accepted, this was a mistake, there was no malice. And obviously, as we know, the correct evidence was put forward at the retrial and she was convicted. However, the significance is that there was one incident where they said she was alone, when the doctor came in and found her. And the key swipe evidence shows actually no, another nurse had returned to duty that time, so she wasn't alone. However, the jury is still convicted. But, I can see why people say, well, hang on, this does seem significant. Can she appeal on the back of this? Well, obviously she couldn't appeal in relation to the retrial because the correct information was put forward. But what about the first trial? Well, first of all, she'd have to show that this was, significant. But can she appeal? Well, no, she can't, because she's already attempted to appeal and she's been knocked back. But now that, of course, new evidence has come to light, or rather, it's come to light that the previous evidence was incorrect, can she do anything there? Well, yeah, she can apply to the Criminal Cases Review Commission. And if she can persuade them that this material might have made a difference, they can then recommend to the Court of Appeal that she has a second attempt at appealing. I mean, it's not automatic. All the CCRC does is say, yes, we think there is something here that does warrant a second appeal. But does it really? I mean, what they would have to show is that this went to something significant and at the heart of the original trial. So no doubt the defence will be going, right, first of all, is this significant to any of the counts? Well, the problem is, it seems that it was only significant in relation to the count that the jury couldn't agree on. So unless they can actually pinpoint something in the first trial where this, was relevant, then it's difficult. But let's assume they do. Even if they say, well, look, where she was at a particular time and whether she was alone, that was actually something that was put into evidence, and the prosecution, made a point about it and said, members of the jury, this is something that, you can take into account when considering her guilt, and we say that it shows, a tendency towards guilt. The problem there is, even if that is proven, the test is quite a high one. It's not just that something was wrong, it's had this information been correct, might the jury, it's quite a high standard, it's more, would the jury have come to a different conclusion? Now remember, this was a very, very long trial, and I know people are commenting about all sorts of things. I would remind people that she had an excellent defence team, and they chose to run the defence they ran. Bearing in mind they'd access to all the information, and they had, they could run any defence they wanted. So why didn't they run the statistical evidence? Well, the argument probably is that they knew that if it was tested, and if the prosecution could call counter-experts, it might not hold up to scrutiny. This is why we basically say to juries, only consider the evidence that's put in front of you, and why we have all these rules about contempt of court and not sort of publicising evidence or material that isn't going to get tested in court. Because, it's okay sort of just like reading something and going, well, that seems very significant to me. But you've not seen the counter-argument. You've not seen what other experts might not say. You've not seen what cross-examination questions there might have been on this. I mean, like I say, juries always get this direction, you know, that you must not take into account anything beyond the court because it doesn't get tested. And the way a lot of judges put it is, you know, if you yourself were up for something, you know, whether you're in trouble at work or you're on trial, would you want the jury taking into account, or your boss taking into account, something somebody had told him about you down the pub? You know, which you don't even know about. So you don't get it's not only do you not get a chance to say, well, hang on, that's not true and I can prove it, you don't even know that your boss is considering that. So it never occurs to you to actually change it, to challenge it. So that's my guess. I mean, no doubt the defence will rack through this and they will try to see if, you know, there is anything in. Because one thing when you're appealing, to deter unmeritorious appeals, while your appeal is pending, any time that you are in prison pending your appeal, if the appeal's not back, the judges can say, well, that time therefore doesn't count. You know, and that's to sort of discourage people just for appealing for the sake of it. Obviously, she's on a whole life order, so there's not really a lot to lose there. But it wouldn't surprise me. I mean, the defence might try to bang something into the Criminal Cases Review Commission. You know, they've nothing really to lose except their own credibility. But, you know, that's the issue. So, like I say, my prediction is it's not going anywhere. It wouldn't surprise me if the defence don't even put this before the CCRC, because they're smart people and they'll know that it's a very high hurdle they have to overcome unless they can point to something very specific and say, yeah, this is what they, you know, this is what they got wrong. The prosecution made a big point about this and said this is very important evidence in the case, and now we know it's wrong. The jury would no doubt have come to a different conclusion if they'd heard this. I just don't think they have a runner, like I say, especially bearing in mind the counts to which that evidence does seem to be relevant are the ones that the jury couldn't agree on, and she had the retrial, and at the retrial they correctly identified the evidence. So there you go. Be interested to see what people have to say in the comments. I've really got to stop doing these videos where I'm going over like 1 in 3 hills. But yeah, I'd be interested to see your thoughts in the comments, and if you have any follow-up questions. In the interim, where am I today? I'm at somewhere called Polyjoke, which is a nice little inlet on the north coast of Cornwall that not too many people know about, actually. It's one of these places that the locals know about, but not necessarily the tourists, because apart from anything else, you've got to park quite a long way away. I usually just park in the local pub, because I always assume that as long as I actually buy a coffee while I'm in there, and then one when I get back from my walk, that more or less takes care of the parking, doesn't it? That seems fair. No doubt the next video will be barrister challenges unfair parking ticket from pub. Actually, I've already got one of those on from Wetherspoons.